Hi, welcome to Pat Talks Law. I'm Pat. In today's episode, we are going to talk about medical marijuana and your firearms rights in Missouri. As you know, Missouri just recently passed Amendment 2 for medical marijuana. Now, one of the great things about that is we're going to be able to help a lot of people that need medical marijuana. However, Missourians are gun owners. And this is going to significantly impact the gun rights for Missourian medical marijuana users. So let's look at this because there are two areas we need to look at. Dual sovereignty of federal and state. First, we're going to address federal because that's gotten the bulk of the media attention post the election. Now, there is a case from the Ninth Circuit in Nevada, the Wilson case. Now, that's actually a bad case for gun owners when you think about it. Okay, the Ninth Circuit isn't controlling in Missouri. We're in the Eighth Circuit. However, it's going to be ridiculous for anybody to think that the Eighth Circuit is not going to consider the reasoned opinion of a sister circuit. Now, in the Wilson v. Lynch case 2016, the court applied a two-step evaluation to determine whether the challenged law burdens conduct protected by the Second Amendment, and if so, then they apply the appropriate level of scrutiny. Now, in this case, the court found that intermediate scrutiny was required. Okay, they found that the law only banned the sale of firearms to Wilson, not her possession of those firearms. This is something that a lot of media has gotten wrong. Okay, the Wilson case found that Ms. Wilson could not purchase a firearm after she had her medical marijuana card. And the court did find, and I quote, Wilson could have amassed legal firearms before acquiring a registry card. And 18 U.S.C. section 922 subparagraph D subparagraph 3 and CFR 27 CFR 478.11 and the open letter from DEA would not impede her right to keep those firearms or to use those firearms to protect herself and her home. Now, because the burden was on future acquisition of firearms, not current possession, the court determined that burden was not a severe burden and applied intermediate scrutiny. Because the burden was on future acquisition and not on current possession of firearms, the court determined that that burden was not severe and applied intermediate scrutiny. Intermediate scrutiny requires that the government's stated objective be significant, substantial, or important, and that there be a reasonable fit between the challenged regulation and the asserted objective. That means the regulation has to do what they want it to do. Now, the elephant in the room here on the Wilson case and the Ninth Circuit's decision, quite frankly, in my opinion, is the glossing over the term unlawful. Okay, the definition of unlawful was really only addressed in dicta in that opinion. And the Ninth Circuit may reasonably disagree with my characterization of a portion of their judgment as being dicta, but they started off by saying the discussion was moot. So I'm going to agree with them, their discussion was moot. They were referencing the argument under the Administrative Procedure Act. Wilson said that the open letter was not a valid way to amend the rules that had to go through notice and comment period. However, the court found that, actually agreed with the lower court when they said that that isn't the case. The open letter is an interpretive guidance. It's not a rule that had to be passed. Now, to me, that is the issue on the federal basis for medical marijuana cards and guns. And the court's going to have to address that for relevance in other states. Okay, and we'll talk a little bit more about this and then we'll get into the specific problems with Missouri. Section 478.11 defines an unlawful user as any person who is a current user of controlled substance in a manner other than as prescribed by a licensed physician. Okay, that seems like it would fall clearly under our medical marijuana amendment. However, the government, in the Wilson case, the court, argued that under 21 U.S.C. section 812, marijuana, THC, is a Schedule I controlled substance, meaning that as far as Congress is concerned, marijuana has no currently accepted medical use and treatment. And there is a lack of accepted safety for the use of the substance under medical supervision. THC is a Schedule I drug. However, clearly this is an error. We have so many states that have passed medical marijuana. We have so many doctors that are prescribing it. And the fact is that because the federal government has not approved appropriate studies to consider whether or not medical marijuana is an effective drug or has a legitimate medicinal purpose, is ridiculous. The fact is that it does. At some point that's going to be taken up in federal court and won. However, I don't think it will be by somebody from Missouri. There was a challenge to this classification in February of this year. That was in Colorado in federal court by an Army veteran named Jose Bielen. Now, that case was kicked for Bielen's failure to exhaust his remedies through the DEA prior to taking up the case. Now, I will say, to DEA's credit, it has been moving to consider and reconsider the classification of medical marijuana. And quite frankly, it's going to be faster for us to lobby Congress for a change in the status of marijuana than it is to go through the process of reclassifying it through the DEA. Frankly, I think we're going to have a legislative answer before we have one through the Drug Enforcement Administration. Now, the reality is, in the short run, once you have a medical marijuana card in Missouri, you are not going to be able to purchase a firearm from a dealer. After you disclose your medical marijuana card, you're going to have to, it's a question on the form you have to fill out. Now, that will result in a denial of the sale. Dealers face criminal charges if they sell you a firearm and they know or reasonably should have known that you are a habitual user of marijuana or illegal drugs. And your medical marijuana card is considered a presumptive knowledge of that. So the open letter that we've talked about, there is a copy, it's linked in the description, says that, look, you got to check the box. It says you're no legal drug user if you have a medical marijuana card. If you fail to check the box, you might get away with it for a little while. There's a very strong possibility they won't know until the DEA goes back and they look at the records, but they will catch, they will catch you eventually, and I believe they will charge you and try you and convict you. So don't lie on the federal form. It is not going to be worth it. Now, is this a long way to simply say you're screwed? You can't have guns while you have a medical marijuana card. You know, I started this and my initial thought was no, it isn't. Because you can buy your guns before you get your card and you can keep your guns. The problem is that we're talking about Missouri. In Missouri, you're subject to Missouri state statutes, RISMO Chapter 571.070 specifically, Unlawful Use of a Firearm. Now, a person commits the act of unlawful possession of a firearm if such person knowingly has a firearm in his or her possession and such person is habitually in an intoxicated or drugged condition. It's a Class D felony punishable by up to 7 years in Department of Corrections and a fine up to $10,000. So what does that mean? What is habitually in a drug condition? Well, we don't know how the court's going to rule on that. It really truly hasn't been tested. You know, when I was looking at this, I didn't find a single case where a person was convicted under that section. Prosecutors don't do it. I assume it's because, frankly, it's just too darn hard to make. How are they going to present that you are a habitual drug user or habitually in a drug condition? It's a tough case. Chances are, if you're an habitual drug user, they're going to get you for something else, or they'll get you under the misdemeanor for possession of a firearm in intoxicated condition, 571.030. So my concern here is actually several-fold. First, if you're going to get your medical marijuana card, my advice to you right now is going to be sell or secure your firearms beyond your control when you have that. That means get them out of your house. Don't pull the scam of putting a gun safe in your living room and then telling the officer you don't have the combination. They're not going to believe you, the prosecutor's not going to believe you, and the jury's not going to believe you. Get it out of your house, get it out of your control. That means if you're going to have a medical marijuana card, sell your firearms, give them to your brother to hold on to, but as long as you have that medical marijuana card and you possess your firearms, you are taking a risk. It's not a risk that as a defense attorney I could advise you to take. The statutory prohibition on possession of firearms by habitually or intoxicated or drugged persons, it's rarely, if it's ever been charged. As I said, I haven't found a single reported case with a conviction under that prohibition. However, I think they'll start to use it. And they're going to be able to use the federal case law as persuasive authority. The Wilson case, for example, that we just talked about, is persuasive authority. The mere possession of a medical marijuana card gives rise to the reasonable presumption that you are a habitual marijuana user. So I expect that that charge is going to be filed a bit more as things get rolling here. And it's going to go pretty much like this. There's a report of a person growing marijuana in their backyard. Oh my God, it's terrible. The police are going to come and investigate. They're going to find the weed and they're going to do a search for their safety. And they're going to look around, they're going to find your guns too. You present your medical marijuana card showing you have right to cultivate up to 6 plants. You have the 6 plants or less in your yard. They are registered. You've got the numbers. You can show you are legal with the weed under Missouri law. However, because you have the firearm, instead of saying thank you, have a good day, and leaving, they arrest you for felony possession of a firearm. Or they'll charge you with misdemeanor possession of a firearm or projectile weapon while intoxicated. So I can't advise you to take that chance. God, I wish I could, but I can't. Someone is going to take that case up. Someone's going to be arrested, someone's going to be charged, they'll be convicted, and it's going to go up through the appeals process. And then we're going to know how the court is going to come down on this decision. Whether the medical marijuana card means that your use there is acceptable, or they're going to say no. And we just don't know. That is a slippery slope, however. If they do try and convict somebody under the medical marijuana card for felony possession of a firearm, then what happens to all the people who are prescribed opiates for their back pain? Or they blow their knee out so they get a script for Vicodin. During the time period that they're on those painkillers and they're in that rehab, or their back is being worked on, are they in danger of being convicted under this as well? We are a deer hunting state, and I think that's going to be a big issue. Once we start messing around with hunting and people's gun rights, we just don't know how this is going to come down. It's going to be the subject of a lot of litigation. And remember, we just passed a constitutional amendment protecting your firearms rights. So we don't know what's going to happen. And when we don't know what's going to happen, I and probably most criminal defense attorneys are going to tell you, don't take the chance with your liberty. Wait for the other guy to do it first. Unless you really, really want to do it and you've got the bankroll for the fight, well, then find an attorney that will take that on and go for it. But at this point, look, I can't tell you that that's something you want to do. And it really sucks. But if you get your medical marijuana card, you are probably going to have to accept that you're not going to be able to possess a firearm in Missouri until we have a court decision that tells us how that law is going to be applied.